Hey, Jessica Matthews here from Leverage Legal Group. So let's talk today about how long it typically takes to get a registered trademark, assuming that you qualify for one. If you're not sure if you qualify for one, watch my other videos and that'll help you at least get an understanding of what it takes to qualify. But how long does it take? So this is like, the big question that everybody asks, because generally when you're launching a new brand, you're excited, you want to know that you can, move on with designing the branding and promoting the company and making sales and building, a following and building your social media channels. And it's a little unnerving to not know whether you're going to be able to own your trademark. So let me first of all say, hiring an experienced trademark lawyer is your ace in the hole when it comes to understanding the likelihood of getting your trademark. Because a good trademark lawyer is going to know how to research and read the room and figure out, if there are marks that are going to be a threat to yours or if there's a risk that you're infringing on somebody else. And so generally, if you hire a good lawyer that's going to advise you about those things on the front end, which every trademark lawyer should do that, I certainly do. If they don't, you should find another lawyer. But assuming that they advise you of that and you have a pretty good idea, then let's talk about how long it takes to actually get to registration. So the process is long. Since COVID, it's gotten a lot longer. I'm going to tell you what it used to be and then what is happening right now, because we are seeing, huge delays beyond what was typical. So typically speaking, when you file an application for trademark registration, you usually have to wait somewhere between 3 and 5 months for your application to be assigned to an examining attorney who works for the trademark office, the United States Patent and Trademark Office. That's an internal lawyer that works for that agency, and that is the person that's going to review your file, examine your file to determine whether your mark qualifies for registration. So usually in the past, it would be somewhere between 3 to 5 months. Nowadays, since COVID, it's kind of random. I've had some that are still within the 3 to 5 month range. I've had some take almost a year to get assigned. So I know they've been short staffed. I think the remote working was a real challenge for them, like it was for a lot of people. And so it's a little bit harder to predict. As trademark lawyers, we have to sort of monitor the file, and we really have no control over how long it takes for your file to get assigned to an examining attorney. So that is sort of the waiting game. You have to just wait and see when you're going to be assigned. Now, once you're assigned to an examining attorney, then the process will pick up speed. Generally, in my experience, it's only going to take 2 to 4 weeks to get a response back from that examining attorney. I'm going to do another video that really gets into the details of what types of responses you can get from the examining attorney, but you're going to get one of 3 usually. One is approval. That's obviously in the best case scenario, that's what you want. The next one would be an office action, which an office action is a refusal, but generally it's called a conditional refusal. And depending on what type of conditional refusal it is something that might be relatively easy to overcome. Generally, when you get an office action, the examining attorney is asking for additional information or giving you a chance at least to respond. So there's 2 types of office actions. In the lingo that trademark lawyers use, one is a non-substantive office action, the other is a substantive office action. So of the 2, you hope that you get a non-substantive one. Non-substantive will be relatively easy to respond to. Generally, they're just asking sometimes for additional documentation, another specimen. They may want you to disclaim a word, saying you don't have ownership over that word except for how you're using it in your mark. It's very common to get those. A good lawyer can advise you about whether you should agree to that or not. But those are not usually big hurdles to overcome. Substantive office actions are big ones. So generally that is when you're getting a substantive legal based argument for why your mark will not be registered. Substantive office actions are much harder to overcome, and generally they take time because your lawyer has to prepare basically a legal brief to file with the with the examining attorney to try to overcome the refusal. So depending on what of these three responses you get, now if you get an approval, you're going to then go to what's called publication. So if you're approved, you're approved for publication. The trademark office, before they register any marks, will publish that mark on an online newsletter. They call it the official Gazette for the trademark office. It's published every single day, and your mark has to be published on that for 30 days to give the general public or third parties an opportunity to object or oppose the registration of that mark. So that's public record. Everybody can check that publication and determine whether a mark that's about to be registered is maybe violating their rights in some way, and they can file what's called an opposition. So there's 30 days within which to file that. If no opposition is filed, then generally you're going to go straight to registration. That sometimes takes a month or two. Again, it really depends on the backlog, and it's pretty unpredictable. But if you make it through the publication period without any objections or oppositions, you will your mark will register. So all of that together means that even in the best case scenario, if you get approval right away, no office actions from the examining attorney, you're looking at a minimum of 7 to 8 months. That's best case scenario, and with delays from COVID, you're probably looking closer to a year minimum right now. I'd say 10 months to a year minimum, really, for like smooth sailing. Now, if you have a non-substantive office action, and that's something that you can, respond to your attorney quickly, answer the questions, provide additional documentation, whatever it is they're asking for. Sometimes it's just like an updated address, contact information. Maybe they'll have questions about the owner of the mark, whether it's an entity or an individual. Those types of questions can be answered relatively quickly. In that case, it's really not going to create a huge delay to respond to that type of office action. So it's really not going to take that much longer than if you just had gone straight to approval. Substantive office actions are going to create a massive delay. So generally when you get a substantive office action, you're going to have 6 months to respond, and your attorney is going to need a significant amount of time to do additional research, to gather additional evidence, to talk to you, to research competitors potentially, to research the law, to formulate arguments, to analyze their research, and then to draft this response, which is basically, like I said, it's a legal brief. So that can take a lot of time. So that's not as predictable if you get a substantive office action. I have seen, some scenarios where that can end up dragging out for, 2 years or even longer. So sometimes you can deal with them quickly, but again, it really depends on the specific facts and what the objection was. So, it could take longer than 2 years in that scenario. If you get an opposition during the publication period, so if you pass through, say you address the objections from the examining attorney, you respond to the office action, your lawyer does, and you basically change their minds, and then they approve your mark. They're approving it for publication, so then it's going into that 30-day publication period we talked about. So assuming that you get to that point, if you get objections or oppositions from third parties during that publication period, that is when it can take a huge amount of time, because that can be the basis that a lawsuit can start. And there can be a long time where you're negotiating, trying to resolve it, and sometimes you end up in litigation. So you really don't want to face an opposition if you can avoid it. That is why you have to hire. My strongest recommendation is you hire an experienced trademark lawyer who is very good at doing the research up front, so that before you even file your application what you're facing. Are you going to face opposition? Are you going to face an objection or a refusal from the examining attorney on substantive basis? These are things you need to know before you even file your application. So again, highly recommend you hire a lawyer to assist you in this process. It's going to save you a ton of time and prevent you from making mistakes. And you will have the fastest result with a good trademark lawyer involved than you would if you tried to do this by yourself. So anyways, that is generally how long it takes. Again, it's not super predictable. The good news is once you're on file, assuming that your lawyer's done research and you're feeling pretty good about your chances, you really can begin to build your brand. You don't really have to wait for the outcome of the trademark examination process. You can go ahead and start moving forward. There are always times that you could get a refusal from the examining attorney that you didn't expect, or an objection from a third party you didn't anticipate. I would say that's happened to me less than a handful of times my entire practice. And I've been practicing for 26 years. And I've been focusing solely on trademarks for, 12 or 13 years now. So it's not often, if you do your research up front, that you get hit with something that you don't expect, but it can happen. So your trademark lawyers are not clairvoyant. They can only go off of the information that's available in the database at the time. But generally, if you guys have done the research up front, you know what to expect, then you should be able to move forward and begin branding and building the business, feeling pretty confident about what's going to happen on the back end. Now, that's sort of oversimplified the process because there could be other scenarios where maybe there is an existing mark that you know about and you want to try to go ahead and get the mark, and you may have to have some negotiations with that party. So there are other situations that could tack on time and expense, but generally what I've outlined are really sort of the scenarios that you could face and the potential timelines. So I hope that's been helpful. If so, make sure you like this video and subscribe to my channel so that you don't miss any of the content that I'm sharing, because I want you to be informed and make good decisions about how to protect your brand and your business, the thing you're spending so much time and money building. Let's make sure you're a success. Okay, I'll see you in the next video.